does not fully support the appeals by the appellants, neither does it fully oppose. We support it to an extent and oppose it to an extent, and we will highlight and we'll be able to demonstrate to what extent we support it and the extent to which we do not support it. I will start with the concept of the basic structure doctrine, which really formed the main part of the entire appeal. And the basic structure doctrine really is an inherent implied provision in the Constitution. The argument by the appellants that the basic structure doctrine appears nowhere in our Constitution is false, for the reason that the basic structure doctrine, in being an implied provision, means you will not see it. You will have to look into the other express provisions in order to pick out an implied provision. And that is not the only implied provision in the Constitution. The issue of separation of powers of state offices, the issue of various other issues really, including even sovereignty of the people, was not mentioned in the older Constitution. And in the case of Njoya, that is what Njoya was saying when he said that it need not be mentioned. It is implied by the very nature of a constitution. In Kesavananda, one of the judges asked, if the parliament is sovereign and can amend any provision of the constitution, can parliament amend the constitution to turn itself into a monarch so that we never have any other elections going forward? And the answer to that is it cannot. And the answer to that comes from the fact that a constitution is not owned by parliament. It's not owned by any of the constituted organs. A constitution is a document that is owned by the people or the sovereign. Let's call it owned by the sovereign, who then writes down how he wants their affairs conducted and hands it down to the constituted organs. Therefore, it is unthinkable that a constituted organ would then have absolute power to change even that document, which was not its own document. However, like any other implied provision in any law or contract or constitution, such implied provisions, are limited only by express provisions to their contrary. That is to say, when we have an express provision that seems to limit the extent of application of the basic structure doctrine, then the basic structure doctrine will be limited to that extent of that provision. In our Constitution, we do not have any absolute bar on the application of the basic structure doctrine. And therefore, because it's a constitution and inherently has the limitation on who can change it, then it means that we will only look for any express provision that tends to limit the basic structure doctrine and how it applies in our country. The other reason why the basic structure doctrine must apply in our country is because our constitution, not out of an abundance of caution, but deliberately asserted that there exists a sovereign in our country, and this sovereign is the people. That therefore means that any other entity that is not the sovereign cannot have absolute power of amendment. So to that extent, it means the basic structure doctrine is applicable. What is the extent of the applicability of the basic structure doctrine? Again, the limitation of the basic structure doctrine lies in the very inherence of the Constitution, in that it has a sovereign. If the basic structure doctrine is applicable, then it cannot be applicable to the sovereign, for the reason that the sovereign can, in fact, for the reason that the sovereign is the sovereign. They can amend whatever they want to amend and let be what they want to let be. Still on the basic structure doctrine, in the constitution making context, the sovereign is really regarded as a sovereign and is called the primary constituent power. That is the power to make and remake a constitution. So the dispute that came before the court is really whether, it should not be whether the basic structure doctrine is applicable or not. The basic structure doctrine, by virtue that we have a sovereign, should automatically be applicable. The question should be whether it is the sovereign that was attempting to amend the constitution or not. If it is found to have been the sovereign that was attempting to amend the constitution, then by default the basic structure doctrine will fail to apply to that extent. And that brings us to the next question of what constitutes the primary constituent power. Now, our constitution contemplates, first, asserts the sovereignty of the people. Secondly, aside from asserting the sovereignty of the people, it dictates that the sovereignty of the people may be exercised under the constitution. Now, sovereignty as a concept is an extra-constitutional notion. That is not to mean that it can only be exercised outside the constitution. It just means that it cannot be limited by the constitution. And any imposition that it must be exercised outside the constitution itself is a limitation on sovereignty, which is not possible. Therefore, we have stated in black and white that the sovereignty of the people may be exercised under the constitution, and in fact, for it to get legitimacy from the constitution and any of the constituted organs, it has to have been exercised in accordance with the constitution, and that is Article 1. So Article 1 is not binding the sovereign that they must act under the constitution. No, it is stating that any of the constituted organs, that is the judiciary, IBC, whatever will be involved in assessing the sovereignty of the people, can only give legitimacy to a form of sovereignty exercised by the people in accordance with the constitution. So it is not a command to the sovereign, it's a command to the constituted organs, which is really what a constitution is. So it is commanding all of us acting as state organs to not give legitimacy to any exercise of sovereignty, although it is there. Someone mentioned about coups and various forms in which a constitution is changed and various ways in which you can reconstitute government not in accordance with the existing constitution. That can happen because sovereignty cannot be limited by the constitution. It's an extra-constitutional entity. However, that sovereignty can decide that it wishes to be guided. And it will state that any sovereignty that should get legitimacy from this constitution must be done or carried out in accordance with this constitution. And that is the remit of Article 1 as per us. I was on the primary constituent power and what really it entails. The primary constituent power, as I said, is the power to make and remake the constitution. Again, it's an exercise of sovereignty of some form, and probably the highest as far as constitutional aspects are concerned. And we might want to try and deduce what is the primary constituent power as far as our constitution is concerned, and that lies in various provisions, but most importantly, aside from the provisions I've talked about, the sovereignty of the people and being exercisable under the constitution, the preamble tells us the kind of sovereignty that established the constitution, because there are different levels of sovereignty. When I go to vote, I really do so as a sovereign member of this country, and many other ways in which the people exercise their sovereignty directly. But that alone is not enough to change the constitution. That me voting alone is not enough to elect the president or to elect a government. The sovereignty is at different levels, and the different levels have to be defined, and that is, I believe, what the Supreme Court is called to do at this point. So the primary constituent power in the preamble, we are told the people, having fully participated in the process of making this constitution, give to ourselves this constitution. And that tells us that the primary constituent power, or the kind of sovereignty that should be adequate to remake or make the constitution, is one which involves the full participation of the people. I believe that's what the High Court was really attempting to bring out when it gave the four-step process of amending the constitution. Unfortunately, it provided a four-step process that seemed to be grounded on the fact that sovereignty cannot be exercised under the constitution, and that is where I dispute the decision of the High Court. So what we are going to be looking for under our constitution, if we are to get the power of amendment that is the primary constituent power under our constitution, we will be looking for which kind of process or kind of sovereign exercise of power under our constitution constitutes the full participation of the people. And this takes me to the two modes of amendment of the constitution. One is a parliamentary initiative and the other is a popular initiative. Now, a validly conducted popular initiative, we believe, is involves the full participation of the people. And this is in contrast to the parliamentary initiative, which is the only other initiative you can amend the constitution with. One, the parliamentary initiative involves members of parliament, and you will get public participation to a limited extent, but not binding to parliament. Then finally, we will have a referendum. The appellants argue that that is a full manifestation of the people's sovereignty with full participation, but we dispute that. Why? Because if you look at the process of amending through a popular initiative, it is obviously more participatory of the people. One, a person is going to come up first with the proposal. This is part of the people. He is going, or she is going to have to sell it out to other people, 1 million of them, who have to be voters, which means for them to get 1 million voters, they will have to sell that idea to much, much more than that, a broader population. After that, it will be taken to the county assemblies, which exercise the sovereignty of the people by dint of Article 3, where public participation will take place. They will then go to the next stage of parliament, where public participation will take place, and parliament is insulated from vetoing it. So that even if parliament were to veto it, it will still go to a referendum, which is again participation of the people. That tells you that even if there was adequate participation in the parliamentary process, there is indeed a fuller participation in the popular initiative. And because there is a fuller participation in the popular initiative, it means the parliamentary initiative cannot be full. And that tells us that the parliamentary initiative is still limited by the basic structure doctrine, whether or not it goes to a referendum or not. However, because the Constitution constrains and says that all sovereign power of the people must be exercised in order for it to get legitimacy from any state organ, must be exercised in accordance with the Constitution, then it means that an exercise of sovereign power that is fully participatory under the Constitution, then that power is a primary constituent power. And that is what we are endorsing, that a popular initiative validly conducted constitutes the primary constituent power. Which takes us to, was this popular initiative validly conducted? Now, inherent in a constitution again, there is a difficulty in the process of changing it. And that is seen in the fact that a constitution is supposed to maintain the stability of government. We cannot have a constitution where it is changed every other day by whimsical feelings of the time. And constitutions the world over have a procedure that tends to make the process of changing the constitution unlike that of changing any other law, to make it deliberately difficult. And that deliberate difficulty is what is seen in the two processes of amending our constitution. One, the popular initiative. For a member of the public to garner 1 million signatures, valid signatures of registered voters, and then goes through the whole process up to the referendum, means that the process of amending the constitution is difficult. But for a member of the public to raise that, then it means that amendment really was necessary. For a public entity or anyone to pass an amendment through the parliamentary initiative, where parliament will have to meet twice, the two houses to meet separately twice, 90 days apart, and raise 2/3 majority all the 4 times, and then still have the possible difficulty of the president insisting that this has to go to a referendum, and still have to go to a referendum and convince Kenyans, that tells you there was a deliberate difficulty put there. Now, when the same public entity decides to use public authority to now collect the signatures, to use public resources to propose and promote, it makes the popular initiative defeat the difficulty that was intended. And that is where 254 Hope had a problem with this process. That what was deemed a popular initiative was not really a popular initiative. It was defeating the deliberate difficulty that is in the process of amending our constitution. And therein, that is where the problem with this initiative came in. So had this initiative truly been an initiative by the two persons who initiated it, without any assistance from the state, and without getting any assistance from public authority, except in their private capacities, then this would be a popular initiative. And I'll go to the question of whether the president can initiate a popular initiative. I disagree with the fact that the two lower courts, either deliberately or somehow, refused to differentiate the difference between Mr. Uhuru Kenyatta and President Uhuru Kenyatta in his official capacity. There is no doubt when the person of the president decides to write a check to pay school fees for their daughter or son, there is no doubt whether they are doing it as the president or in their private capacity. Why it becomes a doubt when they gazette a task force, when they do official functions, then we couldn't get it as 254 hope. We believe that it is very clear, article, not sure if it is 135, which states that a decision of the president shall be in written and signed and with the seal of the president. Once that has been done, then that is, it's presumed that they are doing it in their official capacity. And they cannot turn and claim they were doing it while they enjoy their private rights. The private rights they enjoy, they still enjoy them when they go to vote, when they support a candidate in an election, but they do so in their private capacity, and we never have doubts about that. So the president initiated, or rather proposed, this amendment not in his private capacity but in his official capacity, and that is what made the popular initiative not a popular initiative. Finally, I'd like to go on the question of immunity because it also touches on the separation between the two. We find in our constitution, in the various provisions, there are two types of immunities that are contemplated. One is immunity from prosecution, or rather immunity from proceeding, and the other is immunity from liability. And you look at various provisions, you will find that most officials acting in official capacity have been immunized against liability. That is to say that if you feel that this official violated the constitution and therefore injured you somehow, you can sue this official. The court can find that yes, there was a violation and you can get some remedy, but this remedy will not be held against them personally. That is the immunity from liability. But immunity from proceeding appears in, I think, only two places that I have seen in our constitution. One is the constitution itself, in Article 2, I think, which states that no proceeding can go in any state organ questioning the validity of the constitution. The second place is when we are talking about immunity of the president. And so we can't look at immunity of the president like the usual official immunity that is enjoyed by other state actors. And it's not unusual. Today, I think when we were starting off, the court effectively immunized Amishi, who participate in the High Court, from proceedings subsequent to that in an appeal. Essentially, that was an immunity from proceeding because they can't be named a respondent after they acted as a court. So it's not a concept that is unheard of or that promotes impunity, but it more protects the sanctity, one, of the court, and two, the sanctity of the sovereignty of the republic from embarrassment. And so we are persuaded that the immunity contemplated in Article 143 of the president is unlike other immunities. However, it covers the president as long as they are performing official functions. The argument that the issue of in exercise of powers under the constitution, therefore, if they are exercising powers that are later found not to have been their powers under the constitution, then they are liable. I think that's a fallacious argument, for the reason that by the time the president is exercising their powers or powers they think are their powers under the constitution, they have a duty, which is an official duty, to first make the decision of whether that power is they have it or they don't have it. And they don't do it in their private capacity. They do it as the president. And therefore, one of the functions of the president under the constitution is really to interpret whether they have the power or they don't have the power. So by saying they will be liable when they make a wrong decision in that determination is essentially saying that the immunity covered there has an exception, which is when they make a decision on whether they have a power under the constitution or not. Finally, on the same question of immunity, the issue of 143.3, I think the one that freezes time in both civil proceedings and criminal proceedings during the tenure of the president. You would wonder if the president can be sued when they do an unconstitutional thing. and proceedings continue, why would we want to freeze time, therefore, in a civil proceeding against the president? Yet, the president can't be sued in his personal capacity for a private matter. Therefore, we wouldn't need the freezing of time. I'd like to quickly go to the issue of quorum of IBC, because I initially had ignored it, but I was surprised that it got here. The issue of quorum, one, the Constitution had an implied quorum of IBC. By dint of article, I forget, the article that talks about the commissions and their composition. The Constitution cannot have anticipated a commission that is unable to function. Therefore, even if Parliament did not exercise their sovereign duty to legislate on quorum, suppose Parliament never legislated on quorum in 2012, are we saying that IBC would never be able to function? That cannot be true. Therefore, that's another implied provision in our Constitution, that there is an implied quorum that was dictated by the Constitution. However, that kind of implied provision really is a provision that Parliament has been given a duty to vary. As I said, implied provisions can be varied by an express pronouncement, and Parliament made an express pronouncement in 2012 making the quorum 5. However, when the law was repealed, now this brings me to a second issue, which is what happens to a law when it is found to be unconstitutional. One, why was it found to be unconstitutional? Was it substantive or was it procedural? Because if it was procedural, that is, it was not validly enacted, then that law was not there right from the word go. It was never enacted. And anyone who relied on it relied on no law at all. But if it is substantive, that is, the proper procedure was followed, the law was put in our statute books, then that law cannot be rewritten in a court. The courts are supposed to interpret. It can only be disapplied by the court if it is found to be substantively unconstitutional. So the court will have the dispute before it, and it will disapply that law to the extent that it is unconstitutional. But where the court purports to rewrite the statute, what it is essentially doing, and that's why I disagree with IBC for claiming that it should be let go for relying on the court decision that made them to be constitutional. When a court, or say in this case the High Court, purported to rewrite the statute, what it was essentially doing is binding even the Supreme Court, powers which it doesn't have. The High Court should limit, and any court really, should limit itself to the facts before it, the parties before it, and make a declaration on those. It should be the public bodies that make a decision on how they will interpret that order, whether it will be in rem or they will apply it to those factors. And the public body will retain the accountability for such a decision. We must not transfer the responsibility of defending the Constitution, which is upon all of us by dint of Article 3, to the courts, so that when IBC relies on a determination that is later found by maybe another court or a superior court to be unlawful, IBC will hide behind the fact that a High Court had made that determination. It was still IBC's responsibility to determine whether this court order is constitutional, or rather whether this court order applies to all matters before IBC. And so in this case, I'm essentially claiming that, one, the High Court was not bound by the decision in Biwott and the other decision, and it looked at its facts and made its decision validly. However, the High Court was wrong in assuming that by nullifying the substantive constitution, that the previous court, by nullifying the substantive constitutionality of the statute as was passed in 2017, reverted back to the old statute. No, this remained in the statute books, and it will be upon IBC or any other party who may never have been even in that decision to approach a court on a different set of facts. And if the other court will feel like, no, this statute as applied in this manner, if applied the way IBC was applying it in Biwott, it was unconstitutional. But if applied in another manner, it would be constitutional. And this takes me to the idea of presumption of constitutionality, which, as 254 Hope, while it may not be the substantive core of this matter, as 254 Hope, we've been worried that almost everything that is, the jurisprudence that seems to exist is one where we presume certain acts by states to be by state actors to be unconstitutional until found to be constitutional. And the presumption of constitutionality is not really a common law, just a common law principle. It's in our constitution, in Article 165, where the court is directed to determine if any action that has been done is inconsistent. It's not being told to determine whether it is consistent. It's being told to determine whether it is inconsistent. That tells you that the Constitution presumes that act to be constitutional first, and then it should be proven to be inconsistent. So, and that is really, and especially when it touches on legislation, because legislation is a bit special in the sense that Article 3 provides that sovereignty of the people is exercised by their elected representatives, who is Parliament and the county assemblies. So before a court determines that a law that has been validly passed to be unconstitutional, surely there should be no other way that law can be read to make it constitutional. And that cannot be known until the facts are brought before a court, claiming that it has been read in this manner or applied in this manner. So I'm asking this court to determine a number of things. One, the sovereignty and the remit of sovereignty and its exercise under our constitution. Two, how implied concepts, because when the Court of Appeal made the determination of the basic structure doctrine, I had a headache trying to ask myself, is the basic structure doctrine part of our constitution then? And can it be amended itself? And it's only recently that I came to the conclusion, yes, it is, as an implied provision. And because it's an implied provision that is inherent, it may not be legislated on the same way the implied provision on quorum in the Constitution exists, but that, in my opinion, can be legislated upon without necessarily contravening the Constitution. So, the remit of implied provisions of the Constitution, to how should courts be interpreting when we come to implied provisions of the Constitution, and what kind of limits should be put on violations of implied provisions of the Constitution. Finally, on immunity, I'd like the court to also determine the issue of immunity against proceedings and immunity against immunity from liability, to draw that distinction, and the exercise of power by state actors. I don't really believe that any state actor ceases to enjoy their private rights because they're in public capacity. No. It's just that public offices don't enjoy personal rights. And it's very easy to distinguish between private actions and public actions, because resources follow one and they don't follow another. Public resources, that is. Finally, on the issue of legislation and the validity and invalidity based on constitutionality, because I'm a doctor, I'll give an example of Queen Mary, that is normally known as Bloody Mary. Bloody Mary had tried to conceive for many years, but couldn't. In 1555, she was announced to be pregnant, and her tummy started increasing. And when the time for delivery came, no baby came. And long before we had ultrasounds, what would happen is a patient would be taken for cesarean section to extract the baby who's due and is delaying. And then when you'd extract the baby, you would find that this was a fibroid, not a baby. Alternatively, you might find that this is a dead baby. A dead baby is not a fibroid, it's still a baby. So a statute that has been validly passed, only that it has been found to not be consistent with the Constitution, is akin to a baby that has been validly conceived, gone through the 9 months, delivered, but found not to be consistent with life, and they died. And if later a doctor comes, another doctor with a different opinion comes and listens to the heart rate and says, no, this baby is not dead, this baby is actually alive, we will not go burying the baby and claim that, that the baby was born dead. No. So a fibroid is not a baby. A fibroid was never conceived, did not go through the 9 months, and therefore is not a baby. But a validly passed legislation is a baby that needs the rights of a baby. Thank you very much.
Thank you very much, Dr. I think you have put your arguments very powerfully and passionately, and left us with the questions to decide what we have, whether it's a fibroid or a dead body. That said, I think We would like to stop the proceedings for today now, but before we do so, we would like to see where we are starting tomorrow. We would like to know who else is supporting the first and the second appellants. And I see Senior Counsel Mr. Gatonya. I
Yes.
don't know. Yes.
Yes, my lady, we will be supporting the appeal by the Attorney General.
Okay.
Yes.
And Isaac Arwoche. Sorry.
Your Honor, mine is mixed, partially in support, partially in opposition. So I'll probably go after the President's team.
We'll adjourn and convene tomorrow morning at 9. We'll begin with the 20th respondents, and then I think the 19th respondent, Mr. Aruoche. Then we'll go to the third appellant, and then the main respondents and those respondents who are supporting the third appellant.